SJC-12596, Commonwealth v. Stephen Putnam.
Schnipper, good morning.
Good morning. May it please the court, I'm Merritt Schnipper here for Stephen Putnam this morning. As the court's aware, both this case and the following case involve the construction of Chapter 278A and the category or categories of claimants entitled to seek relief under it. Now, there's no indication in the text of the statute or its legislative history that the legislature intended to restrict the subtypes of innocence claims under which that were available for relief under Chapter 278A. And of course, there's every indication from the legislative history we have that there was intent to remedy wrongful convictions whenever possible by allowing access to forensic testing that might produce objective evidence that could shed light on an innocence claim. Now, the judge in this case denied the defendant's motion because she's found that the issue was not identity, the issue was whether a crime had been committed.
Under Section 3 or Section 7?
Well, it's my contention that it was under Section 3, and I would direct the court, obviously, both to my supplemental filing, in which I make plain I'm attempting to get the defendant, I came in partially way through on a pro se litigation here, and I make it clear from the substance of my supplemental finding that I'm trying to get the defendant over the finish line of Section 3. If you look at pages 19 and 20 of my appendix of the defendant's pro se filing, it's quite plain that he didn't attempt to address the materiality to identification prong at all. So any Section 7 hearing on that motion would have simply just been improper because he didn't make a prima facie case out in his initial filings. That's what I was trying to do. So certainly I didn't believe I was appearing before Judge Ken Walker for a Section 7 hearing. If I had, I obviously would have requested some funds and showed up with my DNA expert. I don't expect her to take my word.
You would have presented evidence.
Excuse me? Oh, yeah.
You would have presented evidence.
Yes, I would have presented evidence, and I would have presented someone who knows more than me about what testing on a 12-year-old pair of pants or a rape kit might show.
I understand. So, no doubt, whether you've been misidentified or no crime occurred at all, if you're in prison and you're innocent, both are equally horrific. But that doesn't answer the legislative intent question. And the legislative intent question seems to refer to the defendant's identification as the perpetrator of the crime. So for all the reasons that you stated in the amicus brief as a remedial statute and Rule 30 is too slow and the sort of crazy result,
Yeah.
You've got, on the other hand, if the legislature wants to limit this to misidentification cases and have other cases move under Rule 30, that's the legislature's prerogative.
I would agree with that because this whole testing procedure is a creature of statute. They can write what they want subject to constitutional limitations, but I don't think that using the definite versus indefinite article in subsection 3 before the perpetrator, a perpetrator, really answers that question. I think what answers that question is the definition of identity in section 1 of the statute, which is not identity defined as the distinguishing features of one individual or another. It's identity as the perpetrator of the offense in the underlying case for which the defendant was convicted. So if you're improperly identified because no crime was committed, by necessity, identity is at issue in the case. And I think the question isn't whether the legislature, there's certainly no plain language in the statute that says only misidentification cases. It certainly uses the word identification, which certainly lends itself to that interpretation. You mentioned the amicus brief. I would point out that this statute was passed in 2012. So the amicus points out in the last 5 years, roughly corresponding to the time in which the statute's been law, there's been over 600 exonerations. That's nationwide, not in Massachusetts. half of those are in no crime cases. So we would literally have to believe that the legislature intended that only half of the innocent people who are wrongfully convicted would be eligible to seek relief under this statute, and everybody else would be relegated to the Rule 30 procedure. But it's impossible to understand. I mean, and I think it's really telling when you look at the legislative history that this court has quoted in Wade, and I believe in Clark as well. There's actually an attorney legislator there testifying as to the insufficiency of the Rule 30 procedure for making the initial access to testing evidence. And the reason that you have to make a prima facie case of potential relief from your entire conviction before you can even access the testing. The whole idea is being able to allow, in a less adversarial posture, access to the testing so that you can see if there's anything there to then go forward and attempt to carry a Rule 30 burden with. So it's entirely counterproductive, and I think, you're not going to read back from subsection 3B4, because you can certainly say that section 2 really identifies the purpose of the statute. Anyone can seek a relief under this statute if you're convicted of a crime in the Commonwealth, you're in prison, and you claim factual innocence. So those are the people at whom the statute is directed.
Does the legislative history, is there anything in the legislative history that suggests they were thinking about this type of distinction as opposed to we have the wrong person?
I certainly don't see, there's no indication that that the legislature says, we're really concerned about these no crime versus wrong person cases. But what we do find is a lack of any reference to mistaken identification procedures, or, and it's interesting that, this statute was also passed at the time when this court was making quite a few decisions like Silva Santiago about identification procedures. It would have been pretty easy for the legislator to have focused in on how often lineups, show-ups, photo arrays can go awry if that was really their primary concern. And I think it is a leading concern because both in the popular culture and in reality, mistaken identifications, as commonly understood, is probably the leading cause of wrongful convictions. This court has mentioned that in many opinions. And it's well known in the popular consciousness as sort of like the worst form of tragedy. But the real question here is, do we find in this remedial statute an intent to limit the accessibility of testing under this lower standard to basically only half of the potential innocent claimants out there? I think you would really need a strong indication of legislative intent to make that finding, because you're cutting off a significant population from the force of this really important remedial statute.
So how do we read the language, though? Has the potential resultant evidence that is material to the moving party's identification as the perpetrator? How do we make sense of that and adopt your interpretation?
Sure. Well, I think we look to the statutory definition of identity, which is not saying, did they find Merritt Schnipper? Was he correctly the guy there? But is this the person who committed the crime? So if you look at both the materiality prong and you look at it in light of the entire purpose of the statute, what you're talking about is identification as connected to the accuracy of the ultimate determination of whether the defendant committed the crime for which he or she was convicted. And if you think about it as that definition, then a false allegation case, any sort of other wrongful conviction fits very neatly into there. Let me give you an example from the amicus brief.
It doesn't fit neatly into the language, but I understand the concern, but I'm also trying to understand how it's going to work, because this is a lower standard, right? And it applies, it's meant to deal also with guilty pleas where we don't have any evidence. I'm just trying to think, it just seems like if we apply this outside of the identification context, there's always going to be some kind of evidence to look at, right? We've got a fight. We have a fight and someone pleads guilty. There's going to be blood to look at.
Sure, there's always going to be, at least in a significant subset of crimes are going to produce some type of physical evidence that can be subject to testing. But if you look at the court's decision in Moffitt last year, where there were cigarette butts that were susceptible to testing to see who might have had them in their mouth, before they were thrown by the side of the road near where the victim's body was found, what we see is that the reason that the court found the judge at the trial court level had properly found it wasn't material to identification wasn't because it didn't have the potential to produce the identification as commonly understood of an individual. It probably would. The question is, what was the connection of the evidence sought to be tested to the underlying crime at issue?
Then there was still a whodunit, though. In Moffitt, because in Moffitt, the defense said, I was just present at the scene because I set up the drug deal, and these other people came and deposited the cigarette butts and presumably shot the victim. And we said, well, it's not only direct evidence of ID, the fingerprint or the DNA left on the cigarette, on the glass, but it also could be the other person who I say did it.
Right. So I think the question here is, what's the distinction that we see in the statute between a crime where we say there's another perpetrator, but the person who was convicted was the wrong person, and there was no crime that occurred, and we need to test it to determine that?
If we read the statute your way, it would include a diminished capacity NGI defense, right?
I completely disagree with that because.
Well, let me ask you something. So
Sure.
if someone says there's evidence that I was not in my right mental state, I pled guilty, but, there's a sweatshirt that needs to be tested, right?
And the sweatshirt needs to be tested
Like,
because.
are there any limits to what you ask us to do?
There's a tremendous amount of limits, and I think the way that the court can both respect the overall intent of the legislature to make this testing available in all appropriate cases.
It's got to be a subset, right? You agree with
Oh,
that?
yeah, sure, it's got to be a
Okay, so
subset.
tell me your limit.
The limit is whether the physical evidence that sought to be tested is directly connected to the crime such that it has the possibility of shedding direct light on the question of whether this person actually committed the crime. So it's very difficult for me to think of an example, but if you had it, where you say, well,
Committed the crime charge, obviously.
well, but like, let's imagine you say, well, the person who identified me, who knew me, was drunk at the time they identified me. And if you test that whiskey bottle that you found over there, you'll see their fingerprints on there, and you'll realize that they were drunk. Well, that's not really evidence. I mean, so you're going to like collateral impeachment type evidence. So that's
No,
clearly
it's
going to
diminished
be out.
capacity. So if the police say they were sober as a judge, right? So if
And I hope that applies.
right. So if the defendant, if the police say the person was sober as a judge, and then the defendant says, no, he was really intoxicated, he drank a bunch of Fireball whiskey that day, and if you look at the Fireball bottle, you're going to see my client's fingerprints on it. Doesn't that fit what you said?
Well, it fits
And now you get a diminished
the
capacity
nexus to the
manslaughter.
crime, but you have another aspect that you have to go with, which is there an assertion of factual innocence? And I would argue that an assertion of factual innocence does not include diminished capacity, and the reason it doesn't, and I talk about this in my brief in the next case, is that there's a big difference between saying I did something that was completely lawful or I didn't do anything at all and I was convicted of a crime, and I did something, it qualifies as a crime, all the elements can actually be satisfied by facts that exist. However, there's a separate legal doctrine that gives a good policy reason for not holding me responsible in the criminal realm for what I actually did.
So if you have a rape and it's going to just lead to evidence of indecent assault and battery, that's not enough? Or assault and battery?
Well, I certainly think it is enough, because the question is, were you properly convicted of the crime of conviction? So, I mean, think about
Okay, so if you said I was convicted of statutory rape, but what I really did was indecent A and B, do you get tested?
mean, on a rape kit that was taken? I would not see why you wouldn't, because if the allegation is this is statutory rape because there was penetration and.
But what's the difference between the drunk part of it with the whiskey bottle and murder versus manslaughter? I'm not getting you.
Oh, in murder versus manslaughter?
Right.
Well, I mean, in terms of diminished capacity.
Right.
Well, I think that because diminished capacity goes to a reason for finding that the actus reus that was performed nevertheless should not be punished, right? Whereas no crime happened, obviously there's no criminal actus reus or potentially criminal actus reus in play. If you're into the self-defense rationale, then you're into lawful conduct that's being criminalized rather than, so that's not a diminished capacity manslaughter defense. But I think diminished capacity, or even more appropriately to discuss necessity, I mean, the concept of, well, I'm going to break the law, I'm freezing cold, I need to get out of the cold, I'm going to enter this property I don't have any right to enter to protect myself from the elements. Courts had a recent case on that. No one claims that a trespass hasn't occurred. What they claim is that there's a policy rationale for relieving that defendant of legal responsibility for it because there's a greater harm avoided. But in the context of a person who says, I behaved justifiably or I behaved in a completely lawful manner, what you've got is a person who didn't commit any act that should be criminally punished, or you've got a person who committed an act that should not have been criminally punished.
So does it have to be a complete defense in your view?
It has to be, so I mean, it's interesting because when the court defined factual
I don't
innocence.
want to bleed into your other case, but I guess
Oh, yeah,
it does,
we're
yeah.
all, I mean, I think counsel for the other cases here too. So I think it has to be a factual defense, not a legal defense. Those lines are blurred because factual innocence in this context is always going to be determined to some extent by the outcome of a legal proceeding. So we're not talking about an omniscient narrator that decides if someone's factually innocent. Ultimately, the consideration is, would this amount to factual innocence before a jury? So it always, there's a little bit of back and forth between that, but I think it does have to be a complete defense to the crime. It doesn't have to be, as this court has said, you don't have to just completely eliminate any possibility of liability. What you have to show in terms of showing factual innocence is evidence that would have had a real, or had the potential to have a real impact on the adjudication.
Counsel, one question with regard to, that your client was found guilty of other charges, is that correct?
Correct.
And those are not at issue in this instance, is that right?
Well, the testing he is going to is not at issue with those charges.
I'm sorry, I couldn't hear
The
you.
testing that he's seeking is only relevant to the rape charge here.
Okay, so to what extent should a court take into account those other charges and the guilty verdicts in assessing whether a crime has been committed?
I think you really have to go statutory crime by statutory crime. So, for
And not
instance,
put everything in context?
I think that's when you go for a motion for new trial under Rule 30 with the evidence that you may have been able to accumulate. But I think for this, it really talks about a crime, imprisoned for a crime, convicted of a crime. So I think you restrict to the crime of conviction.
So just so I'm clear, was the only penetration here with a finger?
That's what's alleged, yes.
Okay, so you would then, if you were to prevail here under Section 3, you would then have to persuade that a finding of the absence of any DNA in the rape kit would indicate that the digital penetration might not have occurred.
That's correct. And then the same, he's seeking to test other items for handler DNA that he supposedly ripped off the complaining witness's body, so the same thing there.
But that's not before us, that if that would be.
I mean, not in my opinion. My sister believes that that was ruled on by the judge, but in my opinion, we're just talking about the Section 3 factors, which I think the only, even when you look at his pro se filing, I think the only thing he really had out of missing was the materiality prong.
So Judge Tucker made a mistake in sending it for a hearing under Section 7?
Well, I'm not 100% convinced Judge Tucker did send it for a hearing under Section 7, and I certainly am willing to plead, my own sort of misunderstanding, given that I stepped in, at Judge Tucker's direction well into this litigation to attempt to, because the first time I appeared for him, I said, well, obviously we have this materiality issue to deal with. It's not addressed in the pro se filings at all. So I looked at that as my initial responsibility, is just to bring it up to speed there. And as I said, I've been, I submitted a request for discovery along with my supplemental filing with a large affidavit from my DNA expert saying exactly the kind of information I would need. And I specifically put in that supplemental filing, this is the stuff I need to carry my burden under a preponderance of the evidence under a Section 7 hearing. I made it clear that I wasn't ready to go forward without that material. So whether I misunderstood it, I just certainly don't think you can look at his pro se filing and what happened at the later hearing before Judge Kenton Walker and say that this was a Section 7
No,
hearing.
it didn't look like a Section 7.
Didn't feel like it to me.
Let me just, I'm sorry.
Go ahead.
So understanding it's not before us, if you got the testing and the results were negative, how does that help your client?
Well, right, that's really what we need the expert for, to talk about, the likelihood that digital penetration would leave YSTR DNA in a rape kit such that it is a meaningful indication of the non-occurrence of the actus reus of rape. So, that's the question that I would need an expert to answer, and obviously need funds and some discovery to do that with.
And that's the concern. The legislature may have had some sense of a limiting principle here and have certain cases proceed under Rule 30. And I understand it's hard to differentiate between misidentification and factual innocence, but the legislature can do that. It seems, other than very few cases, necessity cases, diminished capacity cases, very few cases are not going to end up making the preliminary foundation for Section 3. And so we're going to have Superior Court judges doing these Section 7 hearings with some frequency that comes with that a cost to victims for cases that were 10, 15 years ago. And so the question I have is whether or not, taking all that into account, it's a reasonable interpretation of Section 3 and Section 7 that this statute is for misidentification cases, and other cases have to be addressed through Rule 30.
Well, if it's just the question of the proliferation of motions that may follow, I think one way to really think about that being not necessarily limited, but not being a massive concern, is that the burden is on the defendant, even at the Section 3 stage, to articulate the theory of innocence and then to connect the materiality inquiry to that theory of innocence. And that's going to be where the rubber meets the road for a variety of claimants. Now, a mistaken identification, bad lineup, or whatever is going to qualify. That doesn't necessarily mean that every other case that qualifies simply because mine qualify, that others may not. And, I would point the court to its decision in Wade 2, where there was really just a tremendous amount of evidence of the defendant's responsibility for the rape and assault in that case, where, he answers the door to his bedroom naked and there's a brutalized victim on the bed behind him. And she, makes some words saying to the effect that he was the responsible party, yet he can show up in court and say, and I agree with the decision, but say, test this rape kit, it's material to whether I committed this rape. So what that means is that the idea that simply a person would have to say, the idea that a claimant is going to provide less information. So if Mr. Putnam had simply said, I didn't do this and I want to test this stuff, maybe we wouldn't be here, because we were not going to be talking about his prior statements at the Section 3 or Section 7 hearing stage, really. So the idea that you try to put more meat on the bones of your innocence claim, actually explain to the court the theory of innocence under which you're proceeding and why materiality is relevant there, it's difficult for me to see that as sort of an impediment to justice proceeding under the statute. I think there's going to be people who say, I didn't commit it, even though there's not a wrongful ID. Are they going to be able to articulate the materiality prong? I mean, that has to be a case-by-case analysis. In terms of, there is going to be probably some level of additional time spent at Section 7 hearings, but, the burden has to be carried, and it's the defendant's burden. So I don't think you can preemptively I don't think it's fair to worry, when you think about the potential increase in workflow, I'm not sure that it makes sense to read from that back into a legislative intent to subset only one type of innocence cases and find that that's the only ones that they intended to allow testing in.
All right, thank you.
Thank you very much.
Ms. Horan?
Good morning. My name is Donna Marie Herron, Assistant District Attorney representing the Commonwealth. The motion judge here properly denied the defendant's second motion for post-conviction forensic and scientific analysis under 278A, where the defendant failed to demonstrate that the requested analysis had the potential to result in evidence that is material to his identification as the perpetrator of the crime.
Okay,
Since the
can we
defendant-
let's focus on Section 2. Do you agree that the defendant has filed a motion which, pursuant to 3, asserts factual innocence of the crime, with factual innocence being defined as a person convicted of a criminal offense who did not commit that offense?
Yes, the Commonwealth did not challenge the factual innocence below. I believe a defendant simply has to file an affidavit saying, I did not do this, and he meets that criteria.
Well, let's play that out. So in an arson case, if the person claims that I've got scientific evidence to indicate that it was not a set fire but an accidental fire, that would fit within the framework of factual innocence.
Under that section, yes, then you go to Section 3.
Okay, so, and let's play it out a little bit further. In a baby shaking case, where the person claims that the child fell, and that I've got medical evidence from the examination of the child, which would indicate that this child was not killed by me, but was killed by the results of the fall, that would be factual innocence.
Yes, my reading of the statute, maybe I'm reading it wrong, is they simply just have to allege it in an affidavit. I don't think it's a high burden to meet. I don't think this court has required it to be a high burden to meet.
So Section 2 permits a person to file such a motion.
Yes,
But you're also arguing that because Section 3, in all of the examples that I have given, that motion is doomed to die.
well, first I disagree, and I know I'm probably not going to win on this, but I don't think we're under Section 3. I thought, looking at the procedural history of the case and being that I was the person there the whole time, the Commonwealth was given 10 days to file an opposition. If we
Hold that for a minute, it's important, but can you just answer the Chief's question first, because I really want to drill into that for a moment.
Okay, so yes, then they proceed to Section 3, which the legislator has set. But again, I believe Section 3 simply is a checklist that I left it to the judge's discretion. But yes, they would go to Section 3 and have to allege that meets each criteria of Section 3.
So you're saying the legislature permitted these motions to be brought
Yes,
and identified factual innocence broadly enough to include all of the examples which I have just given, but then in Section 3 said, but we're going to essentially doom all of those cases to die because they've alleged not a misidentification of the perpetrator, but the fact that there was no crime at all.
Yes, because it's not material to the identification as the perpetrator of the crime.
Okay, so why would the legislature do that? Why would it enable individuals to bring a subset of cases and then through rather convoluted language essentially say, oh, we're actually only going to permit a subset of those factually innocent cases, even potentially to prevail?
The legislator set some basic, and I think it's very basic, limits to filing the motion. I believe under Section 3, quite frankly, they just have to do a checklist, and then they get to Section 7, which is where I argue. But even under Section 3, they set some limits, and one of them was it has to be material to the identification of the, potential to be material to the identification of the perpetrator of the crime. And this court in Wade 2, in Lyons, in the below, in Moffett has said it has to result in material identification, quote, in Lyons, potential for material identification. In Wade 2, this court said that the legislature intended to have it provide provision requiring scientific testing to be material to identity. That is this court in Wade 2. So they made some limits. They set some. It's not a lot, but they set some limits that they wanted for the testing.
But if they were to do that, wouldn't they have narrowed the scope of what factual innocence means?
No, because I think factual innocence just allows you to file the motion. It doesn't mean your motion is to be granted.
So, you be the judge. If you have this case, are you saying that it satisfies Section 3 and then we move to Section 7 or not?
I didn't file a response because I believe how this court in Wade 2 has interpreted Section 3. It's essentially a checklist that the defendant has to meet. And I felt...
So your position is, I just want to make sure I understand
Yes.
it and respond. Your position is, as it relates to the preliminary filing requirements, Section 3 has been satisfied, and that we go to Section 7.
I left it to the judge's discretion. At that point, I did not file an opposition because I believe that it's essentially a checklist, and I
Yeah, the judge
don't.
I
I didn't think I'd went
the
on.
clerk for used to say, this isn't meet the press. Answer my question. So the question is, if you were the judge, would this satisfy Section 3 as far as the preliminary showing filing?
Under the case law this court has set, yes.
Okay.
And then we move on to Section 7, which is where I went to, because then Judge Tucker, at the time, gave me 60 days to file a response under Section 4, I believe it is, and then set to hearing date under Section 7, and it was at that hearing date, at that time, that Judge Tucker found that it was not fair to have the defendant go through an evidentiary hearing without counsel, and we began the year and a half of finding Mr. Putnam counsel to represent him, because initially CPCS declined counsel, and that took up a year and a half. And then on the December 11th, 2017 date, we were going to schedule the hearing, and I made the argument under 7 that the defendant, before ordering testing and everything, that the statute doesn't apply to the defendant, because the defendant here is not claiming he wasn't there. It's not claiming, he's claiming that it was consensual and he didn't digitally penetrate the victim. And I argued that under Section 7 of the statute, that issue should be decided first. And he agreed with me and set up a hearing date to argue just that initial section. And then if the defendant won, we would have gone to the evidentiary hearing. If I clearly, Ms. Catmarker, found under that it wasn't material to the identification of the perpetrator of the crime.
So you're saying it meets Section 3, it just doesn't meet Section 7?
Yes.
But how do you get around, I find that odd that you're conceding that point. I mean, factually innocent is defined in Section 1, a person convicted of a criminal offense who did not commit that offense. Then we've got Section 2, asserts factual innocence of the crime for which the person has been convicted. Don't you want to start back at those two sections? I mean, you're
I do, but I feel constrained, honestly, by Wade 2.
You feel constrained by what?
That this court has ruled that it's essentially...
In cases in which all of them were identity cases, we say that this is what Section 3 means, and now you're conceding that in cases that don't involve identity, I wouldn't jump to that conclusion if I were you.
Okay.
But why don't you tell us what the definition means to you? What does factually innocent mean to you? Does it,
Maybe I'm looking at it differently. I just think to assert factual innocence, I don't think Mr. Putnam's factually innocent. I think it's clear he's guilty, but I guess to assert factual innocence just means, to me, filing an affidavit saying, I did not do this. And that's all the defendant needs to do, obviously making the other.
but he's filing, is he filing a factual innocence or a legal innocence affidavit? I mean, I'm just not, is he questioning his factual innocence here? Or is he saying that I'm the person who did it, but I have a legal defense to this? I mean,
I think he's saying it, but I think all he has to say is, I did not commit this crime. That's how I read the Section 2 law, that all he has to say in an affidavit was, I did not commit this
Well,
crime.
if it was consent, then there was no crime. If
Yes.
it's self-defense, then there's no crime.
I guess I read Section 2 as very easily met, is the way I read it. If I'm reading it wrong and this court wants to overrule me, I'll be more than happy for that. I just read it as a very,
But I gather you're reading it that way because your understanding is that this was designed to focus on wrongful convictions, and that you understand factual versus, you understand legal innocence to be, well, maybe I committed the crime, but there was a motion to suppress which should have been granted, or the evidence was too weak to prove me guilty beyond a reasonable doubt, but I did the crime, as opposed to somebody who said, I did not commit the crime. That's what the legislature was focused on. Somebody who actually, we would say, a miscarriage of justice has occurred because the person did not commit the crime.
under Section 2, yes, that gets them to file the motion. And then we move on to whether they can meet the criteria. And I'm arguing that Mr. Putnam has not met the criteria because it's not material to his identification. I think it's two separate things. I don't see it as one thing. And material identification of the crime, particularly in, as I argued below, in the facts of this case where it's digital penetration, and that there was testimony at trial regarding that the pants were.
but if you concede that he may be factually innocent, then isn't this relevant to his identification of the perpetrator of the crime because there's no crime? I mean, if you're conceding that that's factual innocence, then I'm starting to say to myself, well, then Mr. Schnipper's interpretation of identification of the perpetrator may make more sense.
Then I just felt constrained just reading the case law that it wasn't a high burden to meet, and that all this defendant simply had to do was file an affidavit saying, I didn't do this. Do I think that that makes him factually innocent? No, I believe it's clearly what Mr. Putnam's arguing is that he's legally innocent because it was consensual, although he's arguing he did not digitally penetrate her.
Yeah, see, here's the problem. Without commenting on whether or not this statute reaches I didn't do it, or a situation where it's a complete defense like consent or self-defense. It just makes no sense to say, okay, you filed certain papers, so we're going to now go through the expense and the time of having an evidentiary hearing, but after we've done these days of hearings, and sometimes at 4 days, one of these cases was 4 days, we're going to say, no, Section 7, this is not a misidentification case, thanks for the 4 days of testimony, motion denied. So that does, whatever interpretation we come up with, that can't make sense, that you can just go through Section 3 and then spend all that time, money, expense, and anguish, and then just be out after 4 days because it doesn't satisfy Section 7 before, because it's not an identification case.
Then maybe it was my error not to challenge under Section 3, and my argument, that's why I paused at that time and said we need to first establish whether it is relevant to the material, if it has the potential to be material, so maybe it was my error not to argue that under Section 3, and I should have argued it under Section 3. But I don't think this legislator clearly, given the cases I cited, put some limits on, not a lot, but did put some limits on, and one of the, it has to be material to the identification as the perpetrator of the crime, and I argue that Mr. Putnam has not satisfied that, because he admits to being there, he admits to everything up to the digital penetration, so I argue that the case law, the case law and this legislature has put some limits on, and that's where they put the limit.
So this hearing before Judge Kenton Walker didn't walk, talk, look, taste, or feel like a Section 7 hearing. And how can we say this is a Section 7 hearing? Maybe it was supposed to have been a Section 7 hearing. I certainly see, or maybe that's what was supposed to happen, but it certainly doesn't seem like it actually was one.
I guess because the Commonwealth had argued under Section 7 and looked at the record of the case, which I still believe under Section 3, Judge Kent Walker could have done, looked at, because the statute, the case law says you can look at the record, you just cannot make credibility determinations, which I did not ask her to make, nor did she make. I simply was learning the judge to go back and look that Mr. Putnam consistently throughout the whole case has always said, I was there, it was consent. I didn't digitally penetrate her, and in my filings, I was just asking her to recognize that without making any credibility determinations. So to answer your question, I guess it was a quasi 3-7 because we had ordered an evidentiary hearing, and I had filed my response as I'm supposed to under 7 and argued by proponents of the evidence, but we did not have any evidentiary hearing because I guess at this point I said, before we do the 4-day hearing, let's first answer this initial question. So again, maybe I should have filed that under Section 3 at the time and argued it then, but that's where we got when we were in front of Judge Kent Walker.
Did you look at the legislative history here? Have you read through the whole history? Because, I mean, these type of things tend to be stimulated by,
Yes, they wanted easier access for defendants to.
Have you done that? I mean, I'm just trying
I
to.
did read the legislative history.
And did the legislative history, was it all about, we've got the wrong guy, or is there this ambiguity creeping into the legislative history suggesting that these different types of tests are what the legislature wanted? I know the legislative history in Massachusetts tends to be not very helpful, but
I think it was, they did not clearly say, no, we want this only for people who say misidentification, as in it wasn't me, it was them. The legislative history was to allow easier access for defendants under the Rule 30. But my argument would be that in the statute where they wrote it, they made it clear what they were doing.
the language that we're dealing with, the Section 4 language about identification of the perpetrator, was that in all the original bills? Do we have any understanding of how this evolves?
I wouldn't be able to answer that right now, I'm sorry. If there's no further questions, the Commonwealth will rest on its brief and ask this court to affirm Judge Kent Walker's order denying the defendant's second motion for post-conviction DNA testing under 278A. Thank you.
Thank you.